Welcome back to Radio Entrepreneurs. I'm Jonathan Friedman, joined in the studio by our next guest, Matthew Yospin of Yospin Law. Matthew, good to see you.
Good to see you, Jonathan.
Matthew,
thank you very much.
Appreciate you coming back. I understand you're a return guest on the show, so it must have gone well the first time. Let's hope we can duplicate that.
I sure hope so.
Excellent. Well, let's remind our listeners about you and what your practice does. I know that you're focused in a particular area, so why don't we hear it from you?
Yeah, absolutely. I'm a patent attorney. I work in patent prosecution for the most part, specializing in software and mechanical devices. So patent prosecution is the process of identifying innovation and patentable subject matter in a company or for an inventor or entrepreneur, and then writing a patent and working with the U.S. Patent and Trademark Office to get the patent issued so that you can protect your innovation. The process is complicated. The U.S. Patent and Trademark Office has a very, very large, very thick book of rules on what a patent has to be, what the formal requirements are, how things have to be presented, both for the text and for drawings. And there's a whole language that's evolved around it. And if you don't use the right phrasing, you'll just get nothing. And you'll also lose any possibility of protecting your rights later, because once you've disclosed something, a clock starts ticking. If you file your patent wrong, you will not get another chance to do it. You can wind up disclosing your invention.
So it does become public information at that point, or not necessarily?
It can, yes. I mean, there's a time lag, and then patent applications get published, and then they're public. And there are other clocks that start ticking. For instance, if you disclose your invention publicly, which can be something that doesn't seem public, like having your friend try it out at a party, even if it's not visible, that starts a 1-year clock ticking. And when that 1 year is up, you cannot patent that invention. It's not possible any longer.
Is it now considered public domain once it's out there?
Yes.
Okay. Maybe the wrong term, but essentially it's...
Yeah. Yeah. So once something has been disclosed to the public, either in public use or on sale, and a lot of trial uses, like build a prototype and try it out, count as public use. The specifics vary, but you want to be very careful doing anything like that, because this 1-year clock starts, and when it runs, that's it. You can't patent it anymore. Patent rights are very tricky. Here's the subtlety. When you get a patent issued, what you have is the right to keep others from doing that. So if your patent is for a better mousetrap or a better chair, you can keep other people from doing it. Depending on what else is patented, you may not be able to actually practice your invention yourself. You may not be able to build your better mousetrap if somebody else has a patent on part of your mousetrap. You may need to license that from them. They may decide, well, I'm just going to block you. I'm not going to license it to you, or you're not paying me enough money. That doesn't mean that you shouldn't try to patent it, because patents have a number of values. One is they can protect what you're doing. Another is they can be used for defensive purposes. So when somebody else comes to you, a patent holder, and says, you're infringing my patent, you can say, well, look, we could go to trial and fight, and we'd all spend tens of thousands or hundreds or thousands or millions of dollars. Or we could license our patents to each other and go on our merry way. And you with your part of a better mousetrap, and me with my part of a better mousetrap, we could both make our mousetraps, and we'll just sell them. Patent troll is a term that was invented by people at Intel in the late 1990s. And they wanted a term that was pejorative towards businesses that were suing them for patent infringement. And specifically, these businesses, for the most part, were what I think should properly be called non-practicing entities or patent assertion entities. That's a company that owns a patent, has a patent or multiple patents assigned to them, but doesn't make anything. And
so aren't actively utilizing their patent. It's basically a defensive measure to prevent somebody else from utilizing it.
Yes, that's right. But they're going on offense with it.
Okay.
And that's the patent assertion entity business model, at least in the eyes of its detractors.